This is absolutely insane, and you need to hear this right now. The Department of Justice just did something nobody saw coming when it comes to the Second Amendment. I'm talking about a federal lawsuit that could change everything for gun owners across America. And it's happening in the most unexpected place. If you care about your constitutional rights, hit that subscribe button and turn on notifications because what I'm about to show you is going to blow your mind. The DOJ just filed its first ever lawsuit to defend the Second Amendment, and they're going after a California sheriff who's been systematically denying thousands of law-abiding citizens their right to carry. This is historic, and the details are even more shocking than you think. Music, the breaking news details the breaking news details. The Department of Justice just made history by filing a federal civil rights lawsuit against the Los Angeles County Sheriff's Department for violating the Second Amendment. This isn't some small complaint or routine investigation. This is the first time the DOJ has ever used the Violent Crime Control and Law Enforcement Act specifically to defend gun rights. Sheriff Robert Luna is being sued in his official capacity for running what federal prosecutors are calling an administrative labyrinth designed to deny constitutional rights. What makes this absolutely unprecedented is that the federal government is treating Second Amendment violations the same way they treat police brutality cases and civil rights abuses. They're using the exact same legal framework that's been used to take over corrupt police departments. The case number is officially documented as United States versus Los Angeles County Sheriff's Department, and the complaint runs over 40 pages detailing systematic constitutional violations. The numbers behind this lawsuit are so outrageous that even anti-gun politicians can't defend what's been happening. They're the shocking statistics. Between January of 2024 and March of 2025, the Los Angeles Sheriff's Department received exactly 3,982 concealed carry permit applications from law-abiding citizens. Want to know how many they approved? 2. Not 200, not 20. Literally, 2 people out of nearly 4,000 applicants got their permits. That's a 0.05% approval rate. The average processing time was 281 days just to get an initial interview scheduled. After that 9-month wait, applicants then faced another 372 days of processing time. That's over a year of additional waiting after already waiting 9 months. Some people waited 1,030 days total. That's nearly 3 full years from application to even getting a decision. By May 2025, there were still 2,768 applications sitting in complete limbo, with interview dates scheduled as far out as November of 2026. Think about what that means. Someone applying for a permit today would have to wait until late 2026 just to have an interview. California state law explicitly requires sheriffs to make an initial determination within 90 days, not 900 days, 90 days. The sheriff's department was violating state law by a factor of 10. Thousands of people simply gave up and withdrew their applications because the system was deliberately designed to make them quit. But what's really disturbing is how this connects to a Supreme Court decision that should have prevented all of this from happening in the legal foundation in the first place. The legal foundation. In 2022, the Supreme Court issued the Bruen decision in New York State Rifle and Pistol Association versus Bruen. That ruling explicitly stated that the Second Amendment protects the right to carry a handgun outside the home for self-defense. It struck down New York's Mayshoe permit system that gave government officials unlimited discretion to deny permits. California had a similar system. After Bruen, California was legally required to change how they issued permits. The law became shall issue, meaning if you meet the legal requirements, you shall receive a permit. Sheriff Luna's department found a workaround. Instead of outright denying people, they simply refused to process applications. They created bureaucratic delays so severe that people's rights were denied through administrative obstruction. The DOJ complaint explicitly states, this wasn't accidental incompetence or understaffing. This was a deliberate pattern in practice designed to nullify the Bruen decision and the Second Amendment itself. Federal prosecutors documented internal policies and procedures that proved the delays were intentional. Sheriff Luna essentially ignored his oath of office to uphold the Constitution. He ignored California's state law requiring 90-day determinations. He ignored federal constitutional law. But there's something even more troubling that the federal lawsuit reveals about how deep this violation actually goes. To the real-world consequences, real-world consequences. While these applications sat in bureaucratic purgatory, Los Angeles County experienced significant crime increases in multiple categories. Violent crime statistics showed that robberies, assaults, and carjackings were rising in areas where these applicants lived and worked. Many of the people who applied for permits had documented threats against them. Some ran businesses in high-crime areas. Others had restraining orders against dangerous individuals. Several applicants were victims of previous crimes and sought permits specifically because they feared for their safety. The Sheriff's Department knew this. Every application includes a detailed explanation of why someone is seeking a permit. These weren't random requests. These were people with legitimate documented safety concerns who followed every legal requirement. They paid the fees, took the required training courses, submitted fingerprints, passed background checks, and provided character references. They did everything the law asked them to do, and in return, they got years of delays while their safety remained at risk. Some applicants reported that during their wait times, they experienced the exact situations they feared: break-ins at their businesses, threatening encounters. The federal lawsuit includes declarations from applicants describing how the delays impacted their lives and safety. This isn't abstract legal theory. These are real people who were denied their constitutional right to self-defense during a time when they needed it most. And here's what makes the federal government's response to this situation completely unprecedented. The unprecedented federal action, the unprecedented federal action. The DOJ is demanding 3 specific remedies in this lawsuit. First, a declaratory judgment stating that the Sheriff's Department violated the Second Amendment through its systematic delays and de facto denials. Second, a permanent injunction blocking the department from continuing these unconstitutional practices. Third, and this is the big one, court-ordered compliance monitoring to ensure the department actually follows constitutional law, state law, and the Bruin decision going forward. That third demand is massive. If the court grants it, a federal judge could appoint a monitor to oversee the sheriff's entire concealed carry permit process. That monitor would have authority to review policies, examine processing times, and report directly to the court. This is the same type of federal oversight used when police departments are found to have patterns of civil rights violations. It's been used in cases of systematic excessive force, discriminatory policing, and unconstitutional practices. Now, it's being used to protect Second Amendment rights. If this lawsuit succeeds, it sets a legal precedent that federal courts can intervene when state or local officials use administrative tactics to deny constitutional rights. That means New York, New Jersey, Maryland, Hawaii, and every other jurisdiction that's been slow walking permits after Bruin could face similar federal lawsuits. This case could fundamentally change how Second Amendment rights are enforced nationwide. If you want to stay ahead of OUTRO, these massive Second Amendment developments that could affect your rights, you need to subscribe right now and hit that notification bell so you never miss an update. Drop a comment below and tell me if you think this federal lawsuit will actually force California to respect gun rights or if they'll find another way around it. Share this information with every gun owner you know because the mainstream media isn't covering this the way they should. Stay safe, stay informed, and never stop fighting for your constitutional freedoms.